Okay, we had promised an interview with Professor Jessica Levinson. She's going to give us some analysis on that Supreme Court motion today that went in favor of the Trump administration.
Right.
So, Professor, if you could hear us, I want to ask if this ruling by the Supreme Court actually gives the federal government more latitude in questioning and detaining people based on their looks, how they talk, and where they work.
It does, at least temporarily. So what we have from the Supreme Court today isn't a full ruling on the merits. Instead, it's one of these quick emergency docket rulings where the Trump administration lost their case in the district court here in Los Angeles. They then lost again in the Ninth Circuit. They went to the Supreme Court, and the Supreme Court said, let's pause this district court judge's decision while the case continues. Now, the district court judge had very briefly said that the way ICE agents were going about enforcing federal immigration law was problematic. And more specifically, that in order to have a reasonable suspicion that people are in this country without proper documentation, that they needed to rely on more than 4 factors, which the judge singled out as essentially not enough to give ICE agents the power to implement the law, to detain people, to ask about their immigration status.
And Professor, we hear detainees saying they were not given due process through all this. How does this ruling affect that, and will they be heard in court?
So this case, as we talked about, is still continuing. It's not a final ruling on the merits. A couple of things to highlight. One, this case is really about the first part of somebody's interaction with federal law enforcement. It's about what do you need as an ICE agent to say, I have a reasonable suspicion that I can detain somebody. That's slightly different than once we get to due process. And what Judge Frimpong here in Los Angeles had said is, it can't just be the color of someone's skin, the language they're speaking, whether or not they're speaking with an accent, where they are, and the job they're performing. Now, separately, there still could be due process claims by people who are detained. Due process is essentially about notice and an opportunity to be heard. And people could still say that once they were put into the system, that they didn't obtain the process to which they were due prior to potentially being deported, for instance.
Well, you know, we believe the Supreme Court is generally finite in their decision. A lot of groups say they are going to push back, so I'm going to ask you, the recourse they have, is it legislative action or actually the Supreme Court hearing another case and reversing themselves?
So at this point, I think the push will be confined to hoping that the Supreme Court, if they hear this case on something called the merits docket, meaning not on an emergency basis, that they basically change their mind, because this is, of course, a situation where we don't have a written opinion. It's not like when you and I talk in June and the court has gotten briefings and they heard oral arguments. So I think the main push right now will be, while this case plays out in the district court, in the Ninth Circuit, and then potentially in the Supreme Court, to try and get the court to basically rule the other way. Then you ask a good question, what else can be done? We are talking about ICE implementing a federal immigration law, so you could see that there are potentially legislative reforms, but at bottom, we are talking about what is an unreasonable search and seizure, and that's a constitutional interpretation issue.
Still so much more to come. All righty, thank you so much for joining us today. Jessica Levinson, law professor at Loyola Marymount.